Hey everyone, and welcome to today's Explainer. Today, we're unpacking something that honestly plays out like a meticulously planned corporate heist happening right now in the Chinese construction industry. We're talking about a really complex legal loophole here, but by the end of this, you're going to see exactly how this corporate shell game works and, more importantly, how international creditors are finally figuring out how to fight back. So imagine this scenario for a second. You're an international contractor or maybe an investor. A dispute pops up, you take it to court, and you win. Great, right? But then, what happens when your Chinese business partner has already transferred its absolute most valuable asset, its government-issued license, to a brand new company? Suddenly, you're left holding nothing but a judgment against an empty shell. You've got this piece of paper saying you're owed millions, but the entity you're trying to collect from, it's functionally a ghost. To really understand how they pull this off, we have to look at what they're actually moving around. In China's construction sector, a company's core asset isn't cash, and it's not heavy machinery. It's an administrative license, specifically the Grade 1 qualification. Now, this isn't just some frame certificate on a wall. It's literally the legal key required to bid on and execute multi-billion-dollar projects. So while it might not jump out on a traditional balance sheet, it's absolutely the golden goose. It is the core operating asset that gives a construction firm its actual value. So let's dive into part 1, the empty shell trap, and look at how a multi-billion-dollar asset just vanishes into thin air. Okay, here's the core architecture of how this trap is set. On one side, you have the parent company, and on the other, a newly created subsidiary. Through what looks like a totally routine corporate reorganization, the parent company quietly strips out its core operating elements. So we're talking the qualifications, those lucrative track records, and all the key technical personnel, and shifts them over to the subsidiary. Why? To isolate their debt. So the parent company is basically left to rot with all the historical debts and defaulted loans, while the subsidiary gets to walk away completely clean, fully armed, and ready to bid on fresh projects. The immediate fallout of this maneuver is what legal experts refer to as functional death. Domestic creditors just hit a brick wall, with courts throwing up their hands and declaring no assets available for execution. But this is especially dangerous for international creditors and foreign partners. Why? Well, because they usually look at this through the lens of Western corporate law. They see these administrative approvals, often called Document 79 procedures in China, and mistakenly assume, oh, this is just the standard corporate restructuring. They completely miss that the real assets have strategically shifted out of reach until it's way too late. Moving right along to Section 2, let's do a little myth-busting and interrogate the excuses these debtors love to use. First up is probably the biggest myth we see. Debtors will aggressively claim, hey, the Ministry of Housing approved our transfer. It's totally compliant with Document 79, so it's a perfectly legal business move. But the reality? An administrative facade doesn't hide civil abuse. Listen, just because a government department rubber-stamped a license transfer for regulatory purposes, that absolutely does not excuse malicious debt evasion in civil court. You cannot use administrative compliance as a shield to trample all over creditor right. Then we have myth number 2. Well, our bank accounts are completely separate, so you can't touch the subsidiary. Wrong again. In the construction industry, operational commingling is just as fatal as mixing your finances. Stripping a company of its core qualifications and the actual key personnel who do the work is highly illegal. Chinese courts are increasingly looking at the economic substance of the operation, not just checking to see if the ledgers are separate. The third major misconception really trips up creditors when they try to fight back. International creditors often fail because they try a quick fix. They just ask the enforcement judge to add the subsidiary to the hook during the execution phase. And honestly, that almost always fails because of strict statutory rules in China. To actually succeed here, you have to file an entirely separate, substantive, legal action known as a personality denial lawsuit. You have to substantively pierce that corporate veil. Which brings us to Section 3, piercing the corporate veil, using the excessive dominance theory. So at the absolute heart of this legal approach is a concept called reverse personality denial. Now, normally when you pierce the corporate veil, you're going after a wealthy parent company that's hiding behind a bankrupt subsidiary, right? But here, the parent is the empty shell. So we flip it. We do it in reverse. The creditor sues the newly enriched subsidiary, forcing it to take on the debts of its controlling, hollowed-out parent. Essentially, we bypass the empty husk and go straight after the entity that's now holding that stolen golden goose. Now, you gotta know, debtors are tricky. A classic move is to claim, oh, we already sold the subsidiary to a third party, so the chain of liability is broken. But nope, wrong again. Chinese courts are actively developing a look-back mechanism for exactly this. The absolutely crucial rule here is that liability is fixed at the very moment the abuse occurs. That joint liability is locked in the second that qualification transfer is registered. It honestly doesn't matter if they sold the equity the very next day. That subsidiary remains on the hook for the debt. Let's jump into Section 4, tracking the evidence trail and gathering those legal breadcrumbs. Because to break through this facade, you need a very specific detective's tool belt. We're talking about key procedural control points. First up, you've got to use lawyer investigation orders to secure administrative archives. You're looking for the zero consideration trap, basically proving that this multi-billion-dollar qualification was moved over without any fair market payment. Next, you track the personnel migration. You literally follow the transfer of registered engineers by looking at their social security records. And finally, you audit the central regulatory project history, the 4 databases in one platform, to show exactly how the subsidiary seamlessly absorbed the parent's entire market advantage. Then, you tie all those breadcrumbs together to build what's called a timeline of malicious intent. Just look at the pattern here. In month 1, the parent company starts defaulting on its major loans. By month 3, perfectly timed, their core qualification magically transfers to the subsidiary. And then in month 4, the subsidiary's equity is swiftly sold off to create a firewall. When you match the transfer date with the onset of those debt defaults, it builds a completely undeniable, logical narrative for the judge. It proves this was a calculated move to evade debt. Now for the best part, Section 5, winning the legal takedown. Let's look at the 5-step staircase to victory. All right, let's walk up the staircase. Step 1, the judge officially confirms there's substantive control between the entities. Step 2, you prove that the transfer seriously lacked fair market payment. Step 3, the court confirms that ripping out this core asset is exactly what caused the parent's insolvency. Step 4, based on that timeline we just talked about, the court legally presumes a malicious intent to evade the debt. And finally, Step 5, the court penetrates the liability, essentially stripping away the subsidiary's independent legal personality, and boom, you can enforce your judgment against an entity that actually has money. Now, as empowering as this legal pathway is, we really do have to acknowledge the unclosed gap here. While Chinese courts are definitely becoming more and more supportive of creditors in these situations, the burden of proof is still incredibly high. Your success depends entirely on your ability to pierce that administrative facade and reveal the underlying debt evasion. And that means creditors absolutely must act fast to secure this evidence before the subsidiary gets further insulated under layers and layers of complex equity. Otherwise, that debt could be gone for good. All of this leaves us with a pretty critical question to chew on. Are your Chinese construction partners slowly shedding their skins? Or are your contracts actually secure? If you're doing business in the sector, you just can't rely on a basic balance sheet anymore. You really have to look at where the core operating elements are housed, and where they might suddenly migrate the second that trouble starts brewing. If you want to stay ahead of these complex corporate risks and really understand the leading edge of Chinese corporate litigation, I highly recommend checking out the author of the report we broke down today. You can follow lawyer Rongqing Zhang on LinkedIn using the link provided. Thanks so much for joining me for this explainer. Keep your eyes open, watch where those assets are really moving, and I'll see you all next time.